Welcome. I am Eve Cooper-Smith. Joining me on today's webinar are my esteemed colleagues, Doris Martin, Chair of our Trust and Estates Practice Group, Susan St. John from Florida, David Morrissey from Virginia and District of Columbia, David Traskey from Maryland and the District of Columbia, Kristen Walsh from New Jersey and New York, and Bianca De Leon from Connecticut and New York. Thank you for joining us in support of National Healthcare Decisions Day. National Healthcare Decisions Day was founded to educate and empower the public regarding the importance of advanced healthcare planning. Advanced healthcare planning is important for people of every age, and what may be important to someone who is young and healthy may be very different from someone who is of advanced age and struggling with a medical condition which is irreversible, incurable, and progressing. So we're going to talk today about the type of documents that you can create and what you should consider when making those documents. These documents are all called advanced directives, which is a term I'm sure you all are familiar with. Advanced directives includes appointing a representative to make healthcare decisions for you when you can't do so yourself, making a living will, which includes instructions regarding your goals and preferences of treatment, actual physician orders, such as a do not resuscitate order, and other orders that address life-sustaining treatment measures, and being an organ and tissue donor. We're also going to talk towards the end of this webinar about the other kinds of documents that you should consider making in conjunction with your advanced directives. So let's start today's discussion with the appointment of a healthcare representative. And I'd like to turn to Dee Dee Martin and ask you, how do you approach this question with clients?
Well, you'd be surprised, and I think this is becoming an increasing comment by clients, but they do ask for the document in order to make a disposition of their wishes and appoint somebody. Typically, they ask for a DNR or a living will, and we have to educate them about what those different documents are and what the document that is most important in New York, which is the Department of Health healthcare proxy form, in which you can appoint an agent, you can appoint a successor to that person, you can state your wishes. You must state your wishes concerning artificial nutrition and hydration if you want your agent to be able to execute those. And we explain to people that unless they sign something like this, if they are in a hospital, there is an order of family members based on relationship that will be authorized to make decisions for you. But that rule does not apply if you are not in a hospital setting. And there are also groups of people within that. For example, if you have more than one child, more than one sibling, more than one parent, and there is no priority among that group, there is no provision for majority vote among that group. So you really shouldn't rely on that, and you should make a decision. And it often comes up naturally in our intake with a new client. And if it doesn't, we will bring this up because we think this is a very important part of their planning that they need to put in place.
I think you raise a good point, Dee Dee, about when it's a surrogate that's making a decision without a named agent, and there are multiple people in the same group who can decide, because there can be disputes among people of the same level, the same priority level, and we certainly have seen that, and it really can complicate the healthcare of the individual. Every state is different, though. How is it different in New Jersey, Kristen?
So New Jersey is similar to New York in many ways, but the form that we use in New Jersey is called proxy directive and sometimes called a healthcare power of attorney. And the person who is designated to make healthcare decisions is called a healthcare representative, not a healthcare proxy like in New York. In New Jersey, there is a statute that provides that if you don't appoint a healthcare representative in a proxy directive, that only a court-appointed guardian can make healthcare decisions for you. However, luckily, there is case law that allows a close family member to make decisions for you in the absence of a court-appointed guardian or a healthcare representative. And the close family member is defined as a spouse, adult child, parent, or sibling. So very similar, but there are definitely some differences that are worth noting. Susan, how about in Florida?
So in Florida, our form is called designation of healthcare surrogate. And you can, a principal can put a lot of things in there. A healthcare surrogate has a lot of authority to make decisions for the principal in accordance with the principal's wishes and their best interest. If there isn't an appointment of a surrogate, if you don't have that form that designates the healthcare surrogate, then we have a statute that allows an order of priority for someone to act as a proxy or a surrogate. And it starts with a court-appointed guardian. They would be first in line to make a decision. Next is what's called a guardian advocate. And a guardian advocate is a person who has the right to really advocate for someone who has disabilities as set forth in the law. And then next is the spouse, and then adult children, parents, adult siblings, an adult relative in a close relationship to the principal. And what that means is that adult relative actually sees the principal regularly, talks to them regularly, does things with them. There's a close relationship. Could also be a close friend. They're next in line. You want to think of this as your BFF. So your BFF could be your healthcare surrogate if you wanted them to and you appointed them to, but if you don't appoint them, they might end up being your healthcare surrogate if there's no one else ahead of them. Last and not least is licensed clinical social worker that's selected by a provider's bioethics committee, but that clinical social worker does not work for that provider. So that's how it works in Florida when you don't have an appointed healthcare surrogate. What about in Connecticut?
Connecticut residents use an advance directive to appoint a healthcare representative. If an individual has not appointed a healthcare representative, doctors will look to their family, spouse, adult children, and similar to Florida, they will also consult close friends if a spouse, adult children, parents, etc. are not available. What about in Virginia?
Yeah, thank you. In Virginia, it's more like New York, but it has some components of the other states' laws that we've discussed as well. Healthcare is appointed by an advance directive, but if that's not done, an attending physician consults with a hierarchy of family members to obtain authorization for care. Like in Florida and some other states, if there are multiple people in one level of the hierarchy, the majority rules for the decision at issue. I know it's a little bit different in Maryland. So, David, you want to tell them about that?
Yeah, thanks. So again, there's some nuances and some differences among the states. In Maryland, in particular, you're going to have your advance directive, and you're going to appoint a healthcare agent to execute your wishes. If for some reason you don't have that person, similar to other states, there's a sort of a priority list in terms of who acts first in the absence of an appointed agent. In Maryland, you have a surrogate decision maker, and that in order of priority, the first person on that list is going to be a court-appointed guardian. And then similar to other states, we have spouses, adult children, and the like sort of on down the line. And it's similar also in Washington, D.C. The order is slightly different, but sort of the same idea controls, right? We've got a set list of people who are going to be able to step in and act on your behalf if you don't have a designated healthcare agent.
So all of these states, if you don't appoint an agent, they all have a priority list of who can make decisions, but it may not be what the principal wants. I mean, I have clients say to me, oh my gosh, I better appoint someone because if it's going to be my sister, I don't like what she's going to decide. So Susan, what do you recommend that clients consider in choosing who an agent should be?
So one of the things we discuss with our clients is what the relationship they have with the person they're thinking about using as a surrogate. Are they close to them? Have they expressed their wishes before? Do they have frequent communication? Is it someone they trust, really trust, because these are going to be healthcare decisions. And they also have to realize by law, this surrogate in Florida has to be able to communicate and act expeditiously. So a lot of times we have clients, they have multiple children and they want all their children to be joint surrogates. We try to discourage that and try to make it the first choice, an alternative, and then an alternative for them. And then we want to also talk to them about, where do these children live? How are they going to work for you and make decisions expeditiously and communicate expeditiously? We go over all of those things and come down to, this person is closer in proximity. I trust this person. This person will be the next. Now, I do have clients that insist on all their children being the healthcare surrogate jointly or severally. And so we have to write it very specifically that most of the time they will act jointly, but if someone is unavailable, they can act severally or individually, always having to follow the principal's wishes and the best interest of the principal in the decision-making process.
That's really interesting, Susan. New York has a similar standard that decisions have to be made consistent with the principal's wishes. And if the wishes are not known, then in accordance with their best interest. But in New York, it's very clear, and in some other states, it's very clear that only one agent can be appointed at a time. Is there a process in Florida for what happens in the event that there is a dispute, or do you recommend that when appointing more than one, they try to choose an odd number?
That's a really good question. If you have an odd number, choose the odd number, because majority will rule. And, our statute that comes into play, if you don't have a surrogate, if you've got multiple members in a class, say adult siblings or adult children, the decisions are made by majority rule. And so we look at it the same way when we write those documents, that you're going to end up with majority. We do put it in the document so that everyone is aware of that, because it gives guidance to the surrogates. The problem arises if you only have two in the class. They're 50-50 and they're split. There's going to be issues that could mean that we're now going into litigation. And of course, Florida has a statute that allows any interested person, any spouse, any parent, any child, any interested person in the outcome of the patient or the principal's health, can actually go and get a court order expeditiously when they think that there's something not going right with the decision-making process. So you have that, but that takes time you might not really have when you need to be acting expeditiously. So we try to discourage having multiples, but I've had a lot of clients that insist on all their children being the healthcare surrogate jointly and then severally if they cannot locate all of them at once. And that's a little hard on a provider too, but at least in Florida, it's not that unusual. So the providers are pretty willing to say, okay, I've got a group here. I've got to listen to the group. And it works okay, but it's probably not my preference. And I would rather see singles, but multiples are acceptable. You've just got to put a good amount of language in the document so it guides the surrogates.
In Virginia, is there a similar option for appointing multiple agents?
There are. It's much more like Florida in this respect than New York, because in Virginia, more than one agent can be appointed, and those agents do have authority to act either jointly or independently. As Susan stated, for Florida, we strongly dissuade principals from naming co-agents, because that can lead to potential for costly and emotional and an inefficient process that ensues if there's a disagreement between the co-agents. Each can act independently, so it could end up being sort of a race to act, but that also could lead to, problems within the family and litigation. But one thing to note is that the standard and generally accepted form of advance directive in Virginia, it only has space for one agent and one alternate to be named. So that sort of has an effect of dissuading the naming of multiple agents, but it can be done legally.
And it's my understanding that New Jersey and Connecticut also have a rule that you can only appoint one agent to act at a time, and then you can have multiple other agents, but each one can only act at a time. So it would be one after another if you want to name all three of your children.
Correct.
In New York, the authority of an agent to start to make medical decisions for the principal does not begin until the principal has been determined by their attending practitioner to not have capacity. Prior to that time, the agent is not entitled to access medical information. They're not entitled to step in and make those decisions. And I understand that that is the case in several other states as well, but there are differences again, Florida being one of them. Susan, can you talk about how that's different?
Yes. So ordinarily the decision-making ability doesn't come into play until a principal has been declared to be incapacitated. However, the declaration of healthcare surrogate can state that it's effective upon signing, or maybe some other instance. So you can have it effective upon signing, and now that surrogate has power to make decisions. However, it should be recognized that while the principal is not incapacitated, that principal's decisions trump anything that the surrogate might say. So the provider, it's a little tough on the providers when you have a document like that, because they have to be very conscious that their principal is not incapacitated yet. And the surrogate, while they have decision-making authority, it cannot trump what the principal is telling the practitioner or the provider that they want as far as their health is concerned.
Again, similar to New York with a slight twist, because in New York views the principal's rights to make decisions for themselves almost as a constitutional right, a liberty interest. And even after they have been determined to not have capacity, which triggers the authority of the healthcare agent to decide, if the principal makes a different decision and does not agree, the principal's decision again trumps that of the agent. And if that's a decision that would be likely to result in an untoward medical event for the principal, if that's going to result in some harm to the principal, there has to be a court proceeding to determine whether the principal has capacity to make that decision before honoring the decision of the agent. And unfortunately, that does happen from time to time. And providers who are trying to, do the right thing and save somebody's life and help them are sometimes caught in the middle here. So I'd like to talk a little bit now about the authority of the healthcare representative to make decisions. I think in all of our states, the representative making healthcare decisions can make any and all decisions that the principal could make, including decisions about life-sustaining treatment. And the only limitation, as Dee Dee said, in New York, which is a quirk in New York's law, is that an agent cannot make a decision about artificial nutrition and hydration unless the agent knows the wishes of the principal or can, with reasonable diligence, ascertain those wishes, which is why, as Dee Dee suggests, in the healthcare proxy documents that we recommend clients sign in New York, we typically say that you should indicate in the instruction section, my agent knows my wishes about artificial nutrition and hydration, so that there's no dispute. But the differences among the states, I understand in Virginia, there's a slightly different form that is used to sort of invoke the wishes of the principal.
Right. So in Virginia, there is just the advance directive. Here, the term advance directive and living will and are used sort of interchangeably. Living will is almost a colloquial reference to advance directive. Unlike New York, the advance directive has all the components of what you are considering, a living will, and those sorts of the decisions that are set forth in what you call a living will in New York. It's for the common purpose of appointing a healthcare agent and communicating that care information that the living will designates as far as you're concerned in New York. In Virginia also, there's a separate, not necessary, but a separate ancillary mental health advance directive that supplements the advance directive, and that addresses details regarding sort of future potential mental health treatment. So that's the sort of different way that Virginia addresses this issue and the posture that we take here.
And I understand that Maryland also has a slightly different form for this kind of advance directive.
Yeah, that's right, Eve. And I mean, and I would say that, as sort of people over the last couple of years have gotten to be more comfortable discussing, mental health treatment issues, Maryland, both Maryland and DC have responded, in kind by having a separate document for folks to be able to express their wishes with respect to their mental health treatment.
In New Jersey, Kristen, what is the authority of a healthcare representative?
So the proxy directive actually allows the principal to select whether the healthcare representative has the authority or will have the authority to make decisions about life-sustaining treatment and artificial nutrition and hydration. And in New Jersey, there's also a separate form, like in Maryland and Washington, D.C., for a mental health treatment. The healthcare representative appointed under the proxy directive does not inherently have the authority to make decisions about mental health care for the principal. So there's actually a separate document for that. So you would have to specify your wishes if you do want to appoint someone to make mental health care decisions. And in New Jersey, you can also do an advance directive, create an advance directive to outline the decisions that you would want for your mental health care in the event that you don't have capacity in the future. And you have to execute that document while you have capacity, but you are letting your healthcare representative for mental health care know what your wishes are in that instance.
Dee Dee, what do we typically recommend in New York with respect to making a living will?
So in New York, there is no official form of living will. The healthcare proxy form issued by the Department of Health is all that you need to have your wishes carried out, assuming that you've had that discussion with your agent or otherwise made your wishes known, or as you said, they can ascertain them. So we shy away from creating those because we have found that in certain instances they can create issues when you may not fall into one of the categories that you've listed. Certainly during COVID, the automatic preference not to be resuscitated or be put on a ventilator made us all think twice about that provision. And because people remained on those and then came off and came back to good health. So we are not keen in New York on doing it because there is no authorized state form. We do not recommend that, and lawyers love to tinker with forms, that you take the Department of Health form and add a living will to it. We like to see that form standing on its own. And in New York, a living will, whatever form it takes, is just viewed as clear and convincing evidence of your wishes. It is not an official form that has any legal bearing beyond that. So clients do ask for them and we do prepare them, but we caution that they are best used in order for you to have that discussion with your agent so that they can say they know what your wishes are. But we do not encourage our clients to give them to their healthcare providers during their hospital admissions or in any other way, but to ask the agent to keep it in their back pocket if they need it as ammunition to carry out what those wishes are. So we're not keen on them here and we would rather not do them, but we will do them because people do ask for them.
As someone who has been practicing in this field for 30 years, I certainly have been involved in my share of cases where the scenario that you're talking about is exactly what happens, where the spouse who is an agent is saying, I know what my husband's wishes are, and this is what he would have wanted, but the living will says something slightly different. And now there's this dispute between what does the living will say, which does stand as clear and convincing evidence of the person's wishes, and the provider is obligated to follow the wishes of the patient, but the agent is now saying something different. And sometimes it's, it goes both ways. It's, you have a living will that says that the person wanted to be a DNR under certain circumstances, and the patient appears to meet those circumstances, but yet the spouse is saying, no, he didn't really mean it in this scenario. He really meant it if he was much, much worse. He's still in some ways able to enjoy life in some way that is perceived. And we've had the flip side too, where someone is insisting that a DNR be implemented or that life-sustaining measures be withdrawn when the person doesn't yet meet the criteria, but they still have this very advanced condition. So I think the point that everyone has made here today very clearly is what's most important is that the principal communicate their wishes to their legal healthcare representative so that as their life changes and things happen and that their agent does know what they really want. And to your point, Susan, sometimes people are more comfortable telling their BFF what they really want and not their children because they don't think their children, they don't want their children to have to make that decision for them. So I think it's really a good point. I'd like to now move to, well, we're talking about all these different states. How do the states, well, let me start with every state that I understand will recognize the documents created in another state. So Susan, again, I'm going to turn to you being in Florida because so many of the folks in the Northeast spend a good amount of time in the winter in sunny Florida. So how
They
does it
sure
work
do.
when,
That's
what
a,
do you
I mean,
recommend?
yeah, that's a great question because we have folks they're heading home by the middle of May. The rest of them, they start heading home in March and keep trickling out until about the middle of May. They're all back in their northern homes. Um, so it depends really on where your domicile state is, and that's what we recommend. So a lot of our snowbirds actually are still domiciled up north. In other words, they don't spend 6 months here, so they don't qualify for residency here. Florida will honor their documents from another state, and they're happy to do so as long as those documents are executed with the formalities that are required by that other state. Those documents will be honored here. Now, we have people who think they ought to have documents prepared for each state. We tell them not to do it. We don't want dueling documents. That becomes an issue. It's ripe for litigation. So if you are a resident of this state, please use Florida to have your documents created. And if you're not a resident of the state, but you're here for the season, please use your domiciliary state because that's the best thing for you. You spend the most time up there, and Florida will honor those documents.
What we do encourage clients to do is when they do change their domicile, that they meet with an attorney in the new state and update their forms, even though they are still valid, to that state's forms, because those are the ones that are most familiar with and readily recognizable. And as we've seen, there are differences among the states, and you can't do certain things naming which, more than one agent. So that is part of establishing your residency, typically, is to update your documents and to be cognizant that these new forms are much more user-friendly because that state is familiar with them and not New York's or New Jersey's or wherever you're coming from.
And I think, Dee Dee, you were saying before that you recommend, certainly in New York, that when people make a healthcare proxy, they use the New York State form. And in my experience, healthcare providers are familiar with the New York State form. And if it's completed in all the right places, it's simply honored. But if you made, in New York at least, a combination healthcare proxy and living will, or the form is something different that an attorney was creative in making, it doesn't mean the form or the appointment is invalid. It just means that somebody's going to have to look at it and make that determination. And very often, as Susan was saying, you're in a situation where somebody's health care needs to be addressed right away. And you don't want any delays in providing medical treatment. Do you find that to be true also in New Jersey, Kristen? You're on mute.
Knew that would happen at some point. Yes, absolutely. I find it's best to use the state form as it's most easily recognizable and most easily interpreted by the people who need to read it and apply it quickly.
So let's move now to talking about do not resuscitate orders, because I know we also had mentioned that that is a type of an advance directive. A do not resuscitate order, I just want to remind everyone that it doesn't mean I don't want medical treatment. It's very specific. It means I don't want I don't want to be resuscitated in the event that my heart stops or I stop breathing. That's the only thing it addresses. It is by law consistent with every other form of treatment. And by law, there's a presumption that people want to live and would want CPR, would want to be resuscitated. So a do not resuscitate is the only thing that would direct a healthcare agent to not provide. But let's spend a little time talking about that because Dee Dee, as you said, clients come in and they say they want a DNR. So what do you tell them when they walk in?
Well, I encourage them to explain why they ask for one, and typically they are really just asking for the healthcare form and perhaps a living will. But if they are in a terminal situation or they are quite elderly, it is something that they may want to consider. And we tell them that that is something in New York that they need to discuss with their physician because it is not a form that an attorney issues. It's something that their physician needs to discuss with them and issue. And there are two forms in New York. There is a hospital form of DNR and there is a non-hospital form of DNR for if you are at home or an assisted living facility, not in a hospital or hospice. So it is something that they often do want and in certain circumstances is appropriate, but it's something that they need to discuss with their physician to obtain.
And I just want to mention that when you use the term hospital, in New York at least, that also includes nursing home. So the DNR form is only applicable in a nursing home or in a hospital. Once you are living in a residence or assisted living facility, people mistake assisted living facility for an institutional setting. It is not considered that. It is considered a community residence. And so it would be important to have a non-hospital DNR in order for it to be honored by emergency medical services or by, hospital emergency room personnel. And Kristen, in New Jersey, is there anything special that people have to have in order to have a non-hospital DNR?
It's quite similar to New York, and there is, it has to be physician ordered, of course, but there is a hospital DNR and a non-hospital DNR, as well as the other advanced direct medical orders that we'll talk about in a bit, I believe.
Bianca, in Connecticut, is there anything special to alert the EMS that someone is a non-hospital DNR patient?
Yes, Connecticut residents can order a DNR bracelet from their physicians. I think Virginia also has a similar program, right, David?
Yeah, that's correct. There is a separate non-hospital DNR form that one could post on the refrigerator. Also, like I said earlier, the advanced directive has a broad combination of sort of directions to give, and there is something like a DNR you'd find in a living will in that advanced directive. But yeah, the Virginia Department of Health has identified two commercial providers that you can purchase if a principal has a durable DNR, like the non-hospital DNR, that they can purchase a bracelet or a necklace that would tell a first responder that they have that, other than posting the form on their refrigerator.
What about in Maryland? Yes, in Maryland, David.
Yeah, so Maryland and DC are a little bit different in that neither state has a standalone DNR document. Instead, it's actually a section on a larger form related to medical orders for life-sustaining treatment. That's what it's called in Maryland. And in Washington, D.C., it's the medical order for scope of treatment, the most form, but they're essentially the same. So you won't see a separate document in either one of those jurisdictions, but if that's something that you're interested in pursuing, then you want to be looking at those the most or the most documents, which I think we'll turn to next.
And before we turn to those other documents, it's important, at least in New York, to understand that a healthcare agent has no authority to act unless you're determined to be incapacitated, and EMS personnel are not authorized to make that determination, even if it's obvious that you are incapacitated. So unless you have that non-hospital DNR or some other indication of that in your record, they will resuscitate you, and families have to make a choice, which is a Hobson's choice of which way to go. Do you call because you see your relative struggling, but then you are undertaking that they will resuscitate because they can have no authority. And I believe that also is for emergency room personnel also. They have to have a physician.
That's correct. And I think you're raising a good point because at the moment in time when you're calling EMS, they just don't know what the situation is. And what people should understand is that in that in the law, there is no distinction between withholding treatment, that's life-sustaining treatment, or withdrawing life-sustaining treatment. So I think that if there are people who misunderstood that, oh, once I'm resuscitated, they won't be able to disconnect that machine, that's not true. If that is consistent with the wishes of the principal, then the healthcare provider will withdraw that life-sustaining treatment measure if that's the direction of the agent and consistent with their wishes. And I should mention too that again, another reason why it's so important to appoint an agent, because the agent can speak easily to any of these issues with respect to what a person's wishes are. In New York, for a surrogate to be making a healthcare decision, such as a decision for concerning the withholding or withdrawal of life-sustaining treatment, there are additional standards that have to be met before that type of decision can be honored by the healthcare provider. So there is some limitation, even though the authority does extend to life-sustaining treatment measures, the person has to really be in a condition or a state where that would be supported. And people may have very different views about when they do want those measures provided and when they don't. So again, appointing an agent who knows your wishes and can follow them is really the best course. Let's talk a little bit about the MOLST form, the Medical Orders for Life-Sustaining Treatment, also known as POLST, Physician Orders for Life-Sustaining Treatment, or MOST, Medical Orders for Scope of Treatment, or POST, Physician Orders for Scope of Treatment. There are several different acronyms that are referred to. Not every state has this form yet, which we'll talk about a little bit, but in general, this is a form that is a brightly colored form. It's intended to document physician or practitioner orders concerning what treatment a person wants or does not want. There is on the first page of the form an option for someone says, I want all aggressive measures or I want only comfort measures. The first page of the form typically covers do not resuscitate orders. The second page of the form typically covers all kinds of other life-sustaining treatment measures like do not intubate. Remember I said a DNR only covers in the event of cardiac or pulmonary arrest. There are lots of circumstances when someone might need to be intubated short of having pulmonary arrest. So if someone does not want to be intubated, they can ask for that type of order to be issued. There are other orders that can be requested are orders concerning artificial nutrition and hydration. A person can choose a trial period. I'll tell you from my own experience, my mother was like, don't count me out, give me a chance. So she wanted a trial period. I made me understand that she really wanted an opportunity to get better, but if she couldn't get better, she didn't want to be maintained that way. So that this form allows someone to get that specific, even including don't transfer me to a hospital. And there's room for other types of instructions too, like no antibiotics, no dialysis, or whatever you want. So that is the type of form that the MOLST is. And I understand that, as you were saying, David Traskey, that the DNR order for someone in a community setting would need to have either in Maryland or in the District of Columbia, the MOLST or MOST form, depending on which jurisdiction uses which form.
Yeah, that's correct. And I would just put in one other plug here while we're talking about it. I know that, a lot of these issues are sort of difficult to broach. A lot of times you see families either that they have difficulty sharing those wishes with each other. And so a lot of times their primary care physician is really sort of the first stop or the first conversation that a lot of people have about sort of what their healthcare wishes may be. And for those folks out there who may be listening who are Medicare beneficiaries, I just want to let you know that since 2016, Medicare has reimbursed physicians to have these types of conversations with their patients. So if you have advanced care planning questions or needs, and you're not sure where to start or where to look, maybe understand that that's a service that can be reimbursed through Medicare.
Susan, in Florida, is there any form like this?
No, Florida does not have the most post forms at all. And, I'm not certain why. At one point in time in 2018, it was attempted legislatively to add that, and it failed. And then it was attempted again in 2019, and it failed worse. They didn't even get to discussion. And I think it's because our advanced directives, while we have a statutory form, you're actually allowed to expand on it. You can put a lot of directions and explanations in your advanced directives. And also with our living will, which is, statutorily driven, there's a simple form in the statute, but you can expand on that as well. And put more instructions as to what you want when you're in those later stages of life where you might have a disease progress that is not going to get better, and you want to be able to make certain decisions. But the other thing is the healthcare surrogate here, they really have a lot of authority to make decisions once the patient's incapacitated. And even again, they could have decision-making authority immediately upon execution of the advance directive. But while the patient still has capacity, their wishes trump, their directions trump. But I think that's one of the reasons we've never adopted it. We do have one healthcare system, I believe it's University of Miami, that does accept, I think, the PULSed form, and they're going to honor it. But I haven't seen anything else from any other healthcare systems mentioning it. But at least University of Miami has gotten on board with it.
Well, let's switch now to some other things that, once we may have passed. Dee Dee, how does someone control the disposition of their remains?
So in New York, if you have not signed a state form, which is called a disposition of remains, in which you can appoint an agent, you can state specific wishes, you can state whether you've made those arrangements already with a prepaid funeral at a funeral home, you are going to face that same ladder of priority in terms of who's authorized. And again, with no priority among a group, no provision for majority rule. So we have seen difficult situations where someone may have been estranged from their spouse for decades, and their companion could not make those funeral arrangements for them and was in fact barred by the family from attending. I've seen a case where a mother had a heartbreaking negotiation with her estranged son-in-law, who she felt was responsible for her daughter's passing, over the wording of the headstone and whether he would be listed as the beloved husband, which would have been abhorrent to her. Or you may have an estranged child who has to consent with the other children and has no interest in helping because they have no relationship. So if you do have specific wishes, if you do have certain people that you want making those decisions, other than the best thing of making the arrangements for yourself in advance and paying for them, which you can do, you really should consider this and make that part of your estate plan as well.
In contrast, Connecticut, if you are married, your spouse automatically has a right to dispose of your assets, even if you have entered into a contract to dispose of your remains in a certain manner. If you are unmarried, you are allowed to state your wishes and appoint an agent to dispose of your remains. How is it in Virginia, David?
Sorry, it's not like that in Virginia. A person could designate who they want to make arrangements for their funeral and the disposition of their remains by any notarized writing. And if it's not designated by a notarized writing, the law says the next of kin can make that arrangement. And so, and then the law sets forth what the next of kin is, and it's relatively logical, but there's always the possibility for a disagreement there. And in the event of a disagreement between one level of a hierarchy of the next of kin, then the disagreeing next of kin can petition the court for an order determining who designates who is authorized to make those decisions about the remains disposition.
Bianca, what other types of documents do you recommend that people consider making in conjunction with their advance directives?
Great question. We also encourage individuals to execute a power of attorney, which is a legal document that allows you, the principal, to appoint an agent, also known as an attorney in fact, depending on the state you're in, to make financial and legal decisions on your behalf in the event you are unable to make them for yourself. This is an important document because without it, you would have to go to court and have a guardian appointed, which can be very costly and emotionally taxing. We're now going to turn over to Dee Dee, who's going to discuss wills and trusts.
The other important document that you should have with the, in addition to the power of attorney, which is almost as important as the healthcare agent designation, is a will. You know, again, if you don't have one, there's an order to who gets to make the decisions. There's no priority among groups if there's more than one in the group, and it makes the you know, the administration of your administration of your estate more costly and lengthy if you don't have something in place. You can choose who the person is who's in charge. That's called the executor, or in other states, the personal representative. You can make provisions for minor children who their guardian will be in the event you and the other parent are deceased. You can say if someone needs a trust to be protected from an estranged spouse, or it's a child with special needs and you want to protect their eligibility for need-based government assistance. It could be a second marriage and you're happy to have your current spouse enjoy the assets while they're alive, but when they die, you want it to go to your children and not their children or their new spouse, because people live a long time and often remarry. So there's all kinds of things that you can and should do so that you reduce family tension, your wishes are known, and there's a roadmap to how to manage your estate in the event of your death. But even with a will, which is not a magic wand over all your assets, you know, you can say, I give everything to X, but if you've entered into certain other, you know, account titles and beneficiary forms, that may not be the case. So Kristen, why don't you tell us about how important it is to make sure your assets and coordinate with your estate plan and things you need to think about?
Yes, Dee, that's very important. And it's something that many clients are not actually aware of. We've found. So if you have a retirement account or a life insurance policy and you've named beneficiaries, you know, when you set up the account or when you first enter into the policy agreement, you'll name beneficiaries for that policy or account. And when you pass away, regardless of what your will says, that financial institution is going to distribute that asset to the beneficiary names on the account. And it can't override, the will can't override beneficiary designation. And similarly for joint accounts, when you have an account held jointly between two people, often it is owned with rights of survivorship. So when one owner passes away, the surviving owner becomes the sole owner of that account. And again, that's regardless of what your will says. So it's very important to consider. And when we sit down with clients to discuss estate planning, we always, you know, review all of the assets and how they're titled and make sure clients understand, you know, what asset is going where. And if there's a change that they want to implement, then we help them with that. You know, we help them address that, whether it's by changing the beneficiary designation or by, you know, addressing the titling of the account or the will or trust accordingly.
Right. And it's so important because often people will put a child on an account really just for convenience purposes. And we will suggest to clients that for small household accounts that they do put one or more of their children on the account so that there's access and monitoring as you get older to make sure you're not being taken advantage of by your caregiver. But that has consequences because that child then is entitled to that money and can say to their siblings, sorry, that's, you know, that's mine. And we don't recommend that, you know, you create accounts, you know, and sometimes people will do that to get the FDIC insurance and have multiple accounts at different places and put different people's names on it when they really don't intend that the people get the money. They're just trying to get the FDIC insurance and avoid probate, the big bugaboo. But, you know, you have to understand that, you know, even when you walk into a bank and get a CD because it has a good rate, or, you know, are convinced by someone to get an annuity, that those designation forms are going to control over whatever your will said. And there are tax consequences to that too. The people who are designated may not be responsible for the estate tax on those assets, depending on what your will says. So it's really important to have a full inventory and discuss each and every asset with your attorney to make sure it coordinates.
I think that's a really good point. I'll tell you on a personal level, I was just looking at an account that I have and realized that the beneficiary designation was not complete. I thought it was complete. I thought I had made it correct, and apparently not. So I think it's a good point to go over what we do. And so the other point I think you're making is certainly in my case as well. When I first made my first will, my children were minors, and so I had different thoughts and concerns. But just like with healthcare decision making, you're young and healthy, you've got some ideas. You start to get older, you start to get other ideas. So you need to update these forms if you have them already, and you need to revisit them. And I don't think that I can stress enough the importance of having an ongoing conversation with whomever you appoint as your representative, whether it's as a power of attorney for your financial issues or your healthcare decisions, that these conversations hopefully become more natural to have. I know it's very hard to have them. It can be more difficult, but what I try to remind people is that it's about how you want to live your life, not about how you want to die. It's about how you want to live your life and what do you want that to look like. And that's really, I think, what the issue is. So I hope that we have answered some questions. We certainly have gone over a lot of topics and covered the gamut of the states in which we can be of assistance for people. And if you have any questions, you can post them in the question and answer section of the webinar, and we will get back to you. Thank you.